Good afternoon, everyone. Thank you for joining us. My name is Mark Pioro. I'm the Deputy Registrar and General Counsel at CRPO, and my co-presenter today is Pam Bialik, Policy Analyst at CRPO. We are here to talk about minors and consent. This is a long time coming. It's been a recurring topic in questions we receive and issues we need to look into in investigations. And we have promised to provide some additional guidance. And so today we will do that to some extent. On the next slide, I want to just cover some administrative matters. So please, everyone remain muted to minimize distractions. The webinar is being recorded and will be on CRPO's YouTube page. And the slides and transcript and some questions and answers will be available as well. While we won't be answering questions live orally, you can use the Zoom Q&A function to write some questions. And we have also answered during our slides questions received in advance on a survey. On the next slide, I just want to take the opportunity to acknowledge that the CRPO office is located on the traditional territory of the Mississaugas of the Credit, the Anishinaabeg, the Chippewa, the Haudenosaunee, and the Wendat peoples. And it's now home to many diverse Indigenous peoples. We also acknowledge that Toronto is covered by Treaty 13, signed with the Mississaugas of the Credit, and the Williams Treaties, signed with multiple Mississaugas and Chippewa bands. We encourage everyone to do some research on the land they reside on and learn more about the history of their region. The next slide is our outline. We're going to begin by walking you through the sources of authority that establish necessary and best practices before moving on to some key concepts. We'll then apply those concepts to specific areas, including payment, consent to treatment, confidentiality, report writing, and complaints. We'll also go over what we hope might be your top 10 takeaways from this webinar before moving into some of the questions that were submitted in the pre-webinar survey. So now, about guiding principles. First, we have laws and rules. These set out what individuals must, may, or must not do in particular situations. They come from various sources like legislation. You may have heard of the Healthcare Consent Act or the Personal Health Information Protection Act, PHIPA, among others. These two pieces of legislation apply broadly across the healthcare system in Ontario. They are not specific just to RPs. A brief note about the Child, Youth, and Family Services Act. It relates to a somewhat specialized field, that is child welfare services, which may involve providing counseling and other services specifically to children involved with CAS and related entities. They have some additional and separate rules. Since it is a highly specific area, we are not talking specifically about those rules. Similarly, regarding sector-specific work, for those working in the public education system in Ontario, the Education Act likewise has some age-specific consent provisions that anyone working in that field ought to be aware of. That's all to say, there may be some other sector-specific provisions that we can't cover today. Aside from legislation, there's the common law, which is law made by judges through court case precedents. Today's general presentation will focus mostly on Ontario legislation and CRPO standards. We won't have time or opportunity to get into specific cases, or court cases that is, but it's just good to be generally aware that they exist. And as I mentioned, of course, college standards, they apply to registrants in their work, and we'll be referring to several of those. It's important to reflect on the limits of laws and rules. First, it might not be clear what rule or whether a rule applies to a particular situation. In other words, there are ambiguous or gray area situations requiring your judgment. Secondly, and similarly, the rules don't tell you what to do in every situation. And that's where this point about ambiguity comes in, and using clinical, ethical, and risk judgment. We need to go beyond the rules sometimes to figure out what to do. So clinical considerations, what interventions might benefit the client or clients, ethical principles, weighing possible courses of action so as to avoid harm, promote autonomy, act fairly, and advance the best interests of children and others. And there's risk assessment, looking at the likelihood and severity of harm to clients, their family, others, and also to yourself. So now my colleague Pam will take over on the next slide.
So there are 8 key concepts or definitions you'll need to be familiar with in order to make the most of this webinar, but also to practice safely. The first is a minor. A minor is any individual under the age of 18, and that is a legal definition and not something CRPO has come to independently. Then we have competence. CRPO defines this as having the skill, knowledge, and judgment to provide the service in question. While CRPO does not have an exhaustive list of what constitutes competency in different practice areas, registrants should reflect on their education, experience, and any additional training to help determine whether or not they are competent. Next up is capacity. Capacity is, according to the Healthcare Consent Act, the ability of the client to understand the information that is relevant to making a decision about treatment, as well as the ability to appreciate the reasonably foreseeable consequences of a decision or lack of a decision. Consent is permission or approval of a course of action or decision, like the decision to begin and continue therapy. In healthcare scenarios, consent is only considered valid when the consent directly relates to treatment, consent is adequately informed, given voluntarily without coercion, and given without misrepresentation or fraud. Consent may be expressed, such as being spoken orally and noted in the client record or in writing as evidence by a signature on a form, or it could be implied or reasonably attributed to the actions of the client. These requirements and definitions of consent exist whether the client is a minor or an adult. Assent is to agree or confirm. In the context of legal decision-making, this means expressing willingness, cooperation, preferences, or in contrast, refusal, unwillingness, or lack of cooperation, even if the person does not formally have capacity to consent. Moving on, we have a substitute decision maker. This is a person authorized under the Healthcare Consent Act and HIPAA to act on behalf of another individual deemed incapable when consenting to treatment or privacy matters. This allows incapable individuals access to treatment when they are unable to provide consent independently. Next up is confidentiality, which is the duty to keep information secret subject to legal limits. Legal limits refers to the legal exceptions in privacy legislation that allow or require professionals to share information. Finally, we have a certificate or report. We note that this includes a letter, summary, or form, whether formal or informal, regarding the treatment of a client. It does not include providing a copy of the client record, though the letter or report would be retained within the client record. Now, Mark will begin to take you through the application of some of these concepts.
Yes, thank you, Pam. So our first topic of application of the concepts and background we just mentioned is all about payment. We'll cover this briefly. The key point here is that payment is separate from informed consent to treatments and informed consent to the collection, use, and disclosure of personal health information. Many therapy practices involve some form of payment, if not fully funded. Maybe the client themselves is paying, someone is paying on behalf of the client, or there's an insurance company either paying directly or reimbursing the client. For today's purposes, the situation of interest is a parent paying for a child's therapy. That payment in itself doesn't say anything about who is the client, who is providing consent to treatment, or what information is being exchanged with whom. So let's say the payer is the parent, the client is the child, and the child is old or mature or developed enough to have the capacity to provide their own consent to treatment. In this case, it needs to be carefully established the expectations regarding any exchange of information. This needs to be done with the client's consent. So to give a very simple example, the therapist can give a receipt to the payer, the parent, showing that the therapy session took place. That may be all the parent needs or gets to know, just to confirm that their payment has been received and the services have been provided. Now let's talk about briefly a parent stopping payment. As a practical matter, a child may be dependent on the parent for transportation, or they may not have the means to pay themselves. So in many cases, practically speaking, stopping payments will lead to the cessation of treatment, even if the child may be willing to continue. It's important to keep in mind, however, the commentary to CRPO Standard 6.1, which, to paraphrase, says, if the payer fails to pay a registrant in accordance with agreed upon terms, this is not grounds for immediately discontinuing services to the client. While the registrant is entitled to be paid for their services, they must place the needs of the client first. Before discontinuing services for non-payment, the registrant should advise the client of alternative services or providers. Related, it's important to resolve any immediate crisis or imminent risk of harm before discontinuing. So now, having discussed payments, I'll hand it over back to Pam to talk about our second topic.
I'm going to take you through some information on consent to treatment now. I do want to note that I'm reading largely from page 61 of the jurisprudence manual, which covers this topic. I am adding a few comments and clarifications throughout. We do recommend registrants review the jurisprudence manual as well as professional practice standard 3.2 on consent. Child and family therapy can present complex consent and capacity issues, including whether a child has the legal capacity to consent to their own therapy. While RPs sometimes face conclusions about capacity on a child's age, the issue is more complex and capacity needs to be determined on a case-by-case basis. So I do want to answer a series of nearly identical questions we received on the webinar survey about age of consent. There is no minimum age of consent to healthcare treatment and health information privacy decisions in Ontario. Everyone is presumed capable unless there's information to the contrary. It's also important to note that capacity to consent can fluctuate over time. Consent is an ongoing process. If a consent form is signed, it needs to be revisited if there are any significant changes to the treatment or risks involved. Also, a person can have the capacity to consent for one type of decision, for example, to receive therapy, but not another type of decision, for example, to receive a certain kind of surgery. A person who is not capable of providing consent requires a substitute decision maker to provide consent on their behalf. While there is no minimum age of consent legally, in practice, certain patterns or tendencies do emerge. That is, many older children, for example, 12 to 17-year-olds, are capable of consenting to their own psychotherapy. They often do not require a substitute decision maker. In borderline cases, registrants should document their clinical opinions about the young person's capacity, including how capacity was determined. Capacity is usually determined by discussing the proposed therapy with the child and asking questions about their understanding of how the therapy itself and of the implications of participating or not participating. Even if a child has the capacity to consent to treatment, registrants should consider with the child whether psychotherapy is in the best interest in their particular context and whether some parental involvement in the therapeutic process is desirable. In general, younger children may not be able to understand the nature and implications of deciding to receive therapy or not. While capacity does need to be determined on a case-by-case basis, many young children will require a substitute decision maker, usually a parent. You can read the jurisprudence manual in Standard 3.2 for more information about the rankings of substitute decision makers. Unless a parenting agreement or order states otherwise, the presenting parent can make decisions about the child receiving therapy. In situations of two-parent families, it is legally permissible to accept the consent of one parent on behalf of another, unless the RP has reason to believe that the other parent does not agree. However, there are risks in not performing due diligence. For example, failing to involve both custodial parents in a child's treatment can limit successful outcomes for the child and is one of the most common complaint issues received by the college. In addition, it is possible that a parent might claim to have sole custody or that the other custodial parent agrees to the child receiving therapy when those turn out not to be the case. It is possible that separated or divorced parents are cooperative, or it is possible that there's conflict. Due diligence can help avoid problems down the road. Registrants are also advised to have policies and practices in place to manage issues relating to obtaining consent to treat children and adolescents. For example, when treating a young child whose parents acts as a substitute decision maker, it is advisable to inquire if the child has another custodial parent, obtain the other parent's consent if applicable, and review any relevant parenting agreements or orders. Including both custodial parents, where applicable and possible, can reduce the perception of bias on the part of the therapist. For example, that the therapist is more aligned with one parent than another. This perceived bias can ultimately interfere with the child's care. In situations where the registrant cannot reach the other parent to obtain consent, the registrant will consider the best interest of the child in making all decisions about proceeding with psychotherapy and will document their attempts to reach the parent as well as the rationale for all clinical decisions made. If a parent has sole custody or a court order or agreement states that one parent can make unilateral healthcare decisions, then that parent can generally serve as the sole substitute decision maker for their child who lacks capacity to consent to treatment. It's also important to note that as a therapist, working with adults doesn't guarantee competence working with children. Likewise, working with individuals doesn't imply competence working with couples or families. Therapy with children in high conflict child custody and access cases, especially those coupled with intimate partner violence, is highly complex and requires significant training and experience supported by regular supervision and consultation. You need to recognize when an area is outside of your competence and be able to say no if a client or issue is outside your scope of competence. If you're moving ahead in these situations, registrants may be required to make complex decisions about psychotherapy with children based on the best interest and wishes of the child. All decisions must be made with appropriate supervision and clearly documented. In such cases, the onus will be on the registrant to provide support justifying their decisions. Treatment cannot be provided if the joint substitute decision makers, for example, two parents with custody, do not agree with each other about whether to consent. In such a situation, the public guardian and trustee, the consent and capacity board, or a court may become involved. In the interim, the child will not be able to receive the therapy disputed by the parents. I'll now turn it back over to Mark to take us through some information on confidentiality.
Thank you, Pam. So confidentiality is governed by PHIPAA and CRPO Standard 3.1. The most basic principle is that personal health information is only collected, used, or disclosed with consent or as permitted or required by law. Personal health information includes not only what's discussed in session, but even the fact that someone is a client. So first, let's talk about disclosure with consent. In general, if a child has capacity, that is the understanding and appreciation that we already discussed, they decide whether their information may be disclosed. The therapist may suggest disclosing some information, let's say to a parent. This is a clinical suggestion. The RP may suggest it if it may help, but ultimately the client or child decides if they have capacity. If the child doesn't have capacity, usually a very young child, then their substitute decision maker, usually a parent, is the one who consents. The custodial parent can access the child's health record. Any decision made by the substitute decision maker, again, usually a parent, must be made in the best interest of the child. There may be some of the same issues as already mentioned, like which parents have custody. Does a court order or parenting agreement say which parent has the decision-making authority? How can you involve the child in the process, even if they are not capable of providing legal consent? And conversely, how can you involve parents if the child does have capacity? I'll illustrate this by reading a case from the jurisprudence manual on CRPO's website with some added comments. And this is just a very simple situation, one of many. So it's under standard 5, scenario 2. It says, Suzel brought her daughter, Hay, aged 5, so essentially lacking the capacity to consent to disclosure of information, to receive play therapy from Ronan. Suzel told Ronan she has sole custody of Hay, and therefore consent from Hay's biological father is not necessary. Ronan requested Suzel provide a copy of the custody order to store on file. Assume that this goes straightforward. There's nothing contentious or deceptive here. A few months into therapy, Ronan received an email from Hay's father requesting Hay's client record. Ronan responded to the email with careful wording so as not to confirm that Hay is a client, since, as I mentioned, confirming this would be a disclosure of personal health information. Ronan went on to write in general that he is not permitted to disclose client information to a non-custodial parent without appropriate consent unless a legal exception applies. So now let's talk about disclosure based on legal limitations. There are various exceptions to consent. We'll talk about a few of them. First, there's mandatory reporting to a children's aid society if a child is in need of protection. There's a lot of information available on CRPO's website, so there's not much of a need to spend time on this. Also, briefly, there's an exception for disclosing information to prevent a significant risk of serious harm. CRPO also has a guideline available on this. It's currently under review. It'll undergo some updates, and you'll hear more about that in the coming months. So the next slide talks about legal proceedings. This is where we see a lot of dilemmas. These often involve custody and divorce proceedings. Often lawyers are involved. So a quick note about lawyers: it can be natural to feel some pressure or urgency when receiving a legal letter. It's important to pause, reflect, and seek advice as needed. Identify who the lawyer is acting on behalf of, because a lawyer is an agent of their clients. It's important to identify if a legal exception is involved. If not, then consent is needed. If yes, it's important to distinguish between legally permitted and legally required. If something is legally permitted, it means you may do it, not must do it. Again, you can get your own advice on this because a lot of these legal topics you may not be familiar with. If it is a may or permissive situation, then you need to decide based on all the circumstances as discussed above, using clinical, ethical, and risk judgment. In contrast, if something is legally required, you must do it. You might hear terms such as a summons, a subpoena, a production order, or a warrant. These suggest something is required. Now, even when legally required, there may still be some options. And again, it's good to get advice because it's not familiar territory. But just briefly, it may be possible in some situations to resolve a matter informally. So maybe there's some time before a deadline to discuss the matter with the relevant parties. Is it possible to reach out and ask, is there an alternative way to satisfy the request? Just to give a very oversimplified hypothetical example, let's say there's this legal process to compel production or disclosure of all of a client's records, whereas all they really want are the start and end dates. That's where a dialogue can come in handy. There's also formal appeals and motions. So there may be a way to legally oppose and overturn a requirement to disclose. But again, that will require legal advice and depend on the situation. At the end of the day, if something is required, then it's required. Consider what you can do in the circumstances for the best interests of those involved. For example, keeping the client up to date, act professionally, and document your actions. The next slide, it sort of sums everything up about confidentiality. We received a few questions like, what can I share with parents if a minor doesn't want me to? Or similarly, at what age or in what conditions are we required to share information about a child with their parents? So here is a sort of mini decision tree. Just as a caveat, this is a simplified analysis for convenience and education. It can suit many situations, but in more complex or contentious ones, you may need legal or clinical advice. So first, determine if a legal exception applies. Again, we talked about some of those exceptions. Decide if it's may versus must. Decide if there's any informal or formal mechanisms to respond to those legal exceptions, get advice, disclose no more information than necessary, involve the clients to the extent possible, use your judgment. And now the second step, if no exception applies, then seek informed consent, providing any applicable options, risks, and benefits. Now here we have a branch of the tree. So A, if the child has capacity, then you only disclose with their informed consent. And second branch, if the child does not have capacity, then the substitute decision maker, usually the parent, decides what is disclosed. The therapist obviously still needs to use judgment and sensitivity about how and when to disclose, and the substitute's decision must be made in the best interest of the child. The next topic I'm going to talk about is report writing. This relates to confidentiality, but it goes beyond it. It's a common theme we see in questions and complaints. As a starting point, Standard 5.2 requires registrants to provide a report or letter on request unless there is reasonable cause not to do so. Let's talk briefly about some of these reasons not to. Very rarely, it could be so upsetting that it would cause harm to write a report. So obviously the wording would need to be written carefully. Perhaps an RP might be sick or extremely busy, but these are just temporary situations that delay the eventual writing of the letter. A major reason is if you don't have the consent to write what you're being asked. Let's look into this. If it's a third party asking, like a lawyer or an insurance company, they might hand you a consent form, for example. Take a moment to read the wording, ensure that what they're asking for, let's say in a cover letter, matches what the consent says. In rare situations, ask yourself if you have any reason to believe this is fraudulent. Potentially contact the third party to verify what they're asking for, but without disclosing unnecessary personal health information, or consider contacting the client or their substitute themselves if needed. The other issue in consent is with joint or multiple clients. It's a bit more straightforward if the client is an individual, but if it's a family or a couple, it can be more complicated. You need to be satisfied that each client has provided consent, whether through themselves, if they have capacity, or through their substitute, if they don't have capacity. If you don't have everyone's consent in a joint client situation, you get into complex territory regarding whether and how much to write. Can you write about one client without mentioning the others, for example? It can be tricky, so it would be important to think about this and get advice. So what can you put into a letter or report? Well, it's good to find out what the letter is for, and everything should be supported by your records. There's the basics, like who is the client, start and end dates. And Standard 5.2 talks about distinguishing between a client's statements, your observations, and your opinion. For client statements, it's important to present them as such. For example, client reports optimism that they can be a successful parent. Your observations obviously are what you saw or noticed. Your opinion, it's important not to mix up facts with opinions. So if a client says something, it's a fact that they said it, that's their opinion. if you adopt it as your opinion, there could be risks. So, continuing with the above parenting example, if the letter says, I think they can be a good parent, then that could be confusing the client's statement with the RP's personal opinion. Doing so is risky, as the RP may not have full information to make that conclusion. Any opinions must be within the RP's scope. So, not communicating a diagnosis for the first time, and not commenting on something beyond your training or where you don't have information. So, the sorts of opinions that are appropriate and flow from the treatment relationship be things like: client appears to be making progress toward their goals. Client is engaged. There is a strong therapeutic relationship. They've shown improved ability to manage stress. These are sort of all opinions within the scope of an RP to make. Once you go outside that, there could be risks. There's also these sort of specialized fields which an RP may or may not be involved in. So, for example, formal parenting assessments. These are comprehensive approaches to recommending parenting time and custody parameters and arrangements. These formal assessments interview different people and possibly community members and make recommendations. RPs tend not to lead this type of work, though they might be involved as part of the treatment team. This relates to the Office of the Children's Lawyer, who delivers justice programs on behalf of youth. They may also involve an RP for what is known as a children's lawyer report. So that's all to say that there's a difference between a sort of standard treatment relationship and letter, and these more formal, extensive processes which an RP may be involved in. In all cases, RPs should seek consent, act within their scope of expertise, and base their statements on their records. Finally, on this topic, on a related note, it's important to acknowledge that RPs may be involved outside of therapy in other roles, such as mediation or parenting coordination. Mediation is obviously dispute resolution, often from a legal angle, and parenting coordination involves working to implement, facilitate, or organize agreements or orders about shared parenting time and decision making. While these services make use of a therapist's skills and training, they are not therapy. We're not going to focus on these areas too much, except to say it's important to ensure informed consent and boundaries and avoid conflicts of interest. To give a blatant example, you don't want to mediate a dispute between parents and then, as part of that mediation, recommends they hire you for therapy. Obviously, that's a conflict of interest. So now I'll turn it back to Pam on the next slide.
So should a complaint come in, there are a number of considerations at play for RPs. If a child's parent files a complaint about the RP, the registrant should consider the following when contemplating whether or not to continue treatment. First, who provided consent for treatment? If the child consented to treatment on their own or has the capacity to consent to treatment, the registrant can technically continue treatment if they take steps to mitigate any conflict of interest. A clinical supervisor should still be consulted in this situation. If the parent's consent was required for treatment, it is likely that consent would be revoked, in which case treatment would need to end. Additionally, is there a custody order or parenting agreement to consider? Which parent or both have decision-making authority? If the child can consent to treatment on their own, the RP should still consider the following: consulting with a clinical supervisor to explore the potential conflict of interest. Can the RP remain unbiased? How will the RP mitigate conflict of interest? Will continuing treatment cause any harm to the client? Are there options for adequate referral, or is this a specialized case? Are there barriers to access that would make a referral challenging? Consider the client's age, presenting issues, length of treatment relationship, and risk of harm to the client if treatment ceases. Who is paying for treatment? If the complainant is paying and refuses to pay once the complaint is lodged, how will the registrant process payment? And finally, if the registrant cannot disclose the fact of the complaint or discuss the complaint with the child, if the child is made aware of the complaint by their parent, how will they process this discussion with the child? In general, registrants who receive a complaint report that the process can be very emotionally taxing. For this reason, in most cases, it will likely be difficult for registrants to provide unbiased care to the child. Now, based on CRPO staff's valuable insights taking questions and complaints in this area for 10 years now, we do want to highlight 10 key takeaways. First, make sure you have the education, training, and competence to provide services to children, couples, and families as applicable. All the more so if you are regularly involved in high conflict family situations. Be prepared to decline or refer in response to requests that are outside your scope of competence. Consult with an experienced supervisor who works in this field to ensure you have a clear understanding of what work is within your scope of practice. Keep in mind that the person paying for services may not be the same as the client receiving services. This may also be different than the person who is required to provide consent on behalf of clients. Carefully document conversations and assessments about consent and capacity. Ensure your role as a psychotherapist is clearly defined at the outset of therapy. For example, you are being hired to provide treatment to the child, not to develop a parenting plan or assess custody or make recommendations of that nature. You should have policies and procedures in place regarding when to verify custody or decision-making arrangements, as well as whether and how to involve parents in their child's treatment. Ensure these policies and procedures are clearly communicated to parents at the outset of therapy. Pause, reflect, and consult with a clinical supervisor and/or a lawyer when receiving legal or lawyer's letters. A request for information from a parent's lawyer is not the same as a court order. Take extra care to ensure appropriate consents are obtained when making disclosures to third parties regarding the care provided to a child. Ensure letters and reports are written using objective, unbiased language. A letter of support for a client should never include the psychotherapist's personal opinions or direct recommendations about the custody of a child. Finally, you must be familiar with relevant laws and processes specific to children, including but not limited to mandatory reporting obligations and the role of the Office of the Children's Lawyer. I'll now hand it back off to Mark to begin to go over some questions we've received.
Thank you. Yes. So the first one here is it appropriate to be a child's therapist and not have either parent included in the sessions as per request of the full custody parent? The child is over the age of 12, but not yet 16. So we can use some of the concepts discussed today. The RP can make recommendations. These are clinical in nature about who ought to be involved, assess the child's capacity to consent to treatment and information exchange. If the child has capacity, obtain informed consent from the child. And if the child does not have capacity, obtain informed consent from the substitute decision maker. Next question. Many organizations note that their age of consent is 12 on their intake forms. Is there any legal purpose for this being so prevalent? So as mentioned, there's no minimum age for consent. It depends on individual capacity, but there's two possible explanations. The first one is that people come to certain ages sort of as a custom or a habit or a tendency or a pattern. 12 is very common. So we humans, we can't sort of fully assess the full complexity of every situation. We need little guidelines or rules to help us. So some people come to 12 as a sort of rough cutoff, but it's important to emphasize that there may be exceptions. There may be somebody older who lacks capacity, and there may be someone slightly younger who is mature enough to have capacity. So you need, even if you have these informal rules, you need to be able to recognize when an exception needs to be made. And secondly, as I mentioned at the beginning about certain legislation, child welfare services, that sector specifically, they do make reference to age 12. So these are a couple of reasons why you do see ages mentioned, thrown around, even though they don't formally govern the situation in Ontario. So the next question. At what age or under which conditions can children request that parents not seek clinical notes about their child? So once a minor has capacity to consent regarding health information privacy, they, the child, decide whether to consent to disclosure subject to legal exceptions. If the minor does not have capacity to consent, then the substitute decides regarding disclosure of the record. Next question, please. I'm just going to take a moment to remind myself how many questions I was assigned to answer. Okay, so how should an RP document in a child's chart an offside comment made by a parent outside session? So this was a session, today's webinar, more focused on consent, but there are record-keeping considerations that arise in child therapy. Specifically, an RP is more likely to have interactions with parents, family, or others outside of session. So some basic guidance is to ask whether the comment or interaction is relevant to the client's treatment or needs to be documented for risk management purposes to prevent further disputes. And always keep in mind that there's some discretion in how to phrase things professionally. It may or may not be necessary to, use the exact words of the person who made the comment. Going on to the next question. In situations where a youth is capable of consent, but parent caregiver disagrees with participation, how do we navigate confidentiality? So again, I'm just reviewing everything we have learned today. If the child is capable, the RP doesn't need parental consent, consider clinical relevance of parental disagreement, only disclose information with consent or if a legal exception applies. Reflect on whether there will be any practical difficulties like payment, transportation, if there is this disagreement. And on the next slide, we have, given that psychotherapists have no legal training, is it appropriate to expect RPs to have the ability to interpret legal paperwork regarding custody or a court order? So we touched on this a little bit, the importance of seeking legal advice if ever in doubt. However, I would add that if working regularly with children and families, RPs should be expected to have just a basic familiarity with relevant concepts such as access, custody, parenting orders, that sort of thing. And the next question is Pam's.
We also received a question asking if there were any separate or additional documentation requirements when documenting consent of minors, and the expectations remain the exact same. Under Standard 3.2.6, registrants document conversations about and indications of consent, including the date when consent was provided, refused, or revoked, as well as options, risks, and benefits discussed, and the method of indicating consent, whether that's oral or in writing, etc. Another question that came in asked about best practices where in a situation, parents are the consenting party, but the child who is in therapy is uncooperative. To use the concepts we discussed earlier today, there is consent, but not assent. From a practical perspective, psychotherapy cannot be provided with an unwilling participant. The therapist may be able to open a discussion about the minor's reasons for not wanting to pursue therapy, but the decision to engage cannot be compelled. Because the child is unable to provide consent on their own behalf, the parent can be informed of the inability to conduct therapy. Standard 3.5 should also be reviewed in these situations. Standard 3.5 is CRPO standard on unnecessary treatment, which notes that registrants only provide therapy when there is a reasonable prospect of benefit to the client, and discussing the option of discontinuing therapy when it has ceased to be effective. Should this situation occur, the child's unwillingness to engage in therapy should be documented, as well as any conversations with the minor or their parents surrounding the unwillingness to engage. We were also asked about the appropriate course of action when a youth under the age of 12 wants therapy but does not have a parent who can consent for them. First, I just want to reiterate, as you've heard multiple times today, there is no firm age in place in which a client is unable or able to consent to treatment. Should you have a client or potential client under the age of 12, capacity should be determined as usual. Should the minor not have capacity to consent and does not have a parent able to provide consent, there may be another substitute decision maker in place. The Healthcare Consent Act, which is linked on the slide, outlines a list and ranking of persons who may give or refuse consent for an individual who is not able to provide consent themselves. Registrants are encouraged to review the legislation, particularly if you routinely work with minors or other persons who are incapable of providing consent independently. Finally, we received a question about the consistency of consent policies and protocols across Canada. We do want to note that different jurisdictions all have their own legislation pertaining to consent and capacity. When working in jurisdictions outside Ontario, and that could be elsewhere in Canada or internationally, registrants do need to review the individual pieces of legislation to ensure they're operating in compliance. I'll now pass it back over to Mark one last time to help us wrap up.
Thank you. So we have responded to questions received in advance, and some of the ones that appeared on Zoom. I appreciate it's difficult to tease out all the complications in this topic area, especially in just barely 1 hour webinar. However, we'll take a look at what we received and see if there's anything to add in writing in the weeks following when we release the slides and the recording. If you have any questions still beyond that, please feel free to email info@ or practice@crpo.ca, and the appropriate department will assist you. On the next slide here, we have some resources that you can click when we send the slides around. And after that, we would simply like to say thank you for coming and listening.